Good evening, all. I, on behalf of the Indian Society of International Law, welcome all the eminent guests present here on the occasion of Justice Rajindar Sachar Memorial Lecture on the topic Right to Food Security, to be delivered by Honorable Mr. Justice P.S. Narasimha Sir, Judge Supreme Court of India, and also the release of book titled Courts and Hunger, written by Sri Sanjay Parikh Sir, Senior Advocate and Executive Council Member, Indian Society of International Law. I would like to welcome all the distinguished guests sitting on the dais and off the dais. It is an honor to welcome Honorable Mr. Justice P.S. Narasimha Sir, Judge Supreme Court of India. We welcome you, sir, to be here with us today to deliver the lecture. Unfortunately, Sri Praveenaj Parikh Sir, President Indian Society of International Law, he could not be present on the occasion due to certain family circumstances. He has conveyed his sincere gratitude to Honorable Mr. Justice Narasimha Sir and appreciation to Sri Sanjay Parikh Sir for his book. I would also like to welcome Professor Manoj Kumar Sinha, Vice President Indian Society of International Law and Director Indian Law Institute, Professor V.G. Hegde Sir, Chairperson Center for International Legal Studies, Jawaharlal Nehru University, and EC Member, Indian Society of International Law, Sri Sanjay Parikh Sir, Senior Advocate and Executive Council Member, Indian Society of International Law, and Dr. Shikhar Ranjan, Secretary General, Indian Society of International Law. I would like to invite all the guests present on the dais and family members of late Justice Rajindar Sachar ji to pay homage to late Justice Rajindar Sachar by offering flowers with folded hands. Thank you so much. Before we begin with the addresses by the distinguished guests present here, I, on behalf of the society, would take this opportunity to invite again the family members of Justice Rajindar Sachar ji to kindly present token of appreciation to our guest, Honorable Mr. Justice P.S. Narasimha Sir. Sir, I request you to please be on the stage, sir. Now, I would also like to invite Professor Manoj Kumar Sinha sir to felicitate sir with the token of gratitude. Thank you so much, sir. Now I request Professor V.G. Hegde sir to present token of appreciation to Sri Sanjay Parikh sir on the occasion of release of his book. Thank you so much. Now I request Professor V.G. Hegde sir to kindly address the gathering with his welcome speech and also introductory remarks about the book Courts and Hunger, authored by Sri Sanjay Parikh sir.
Uh, Good evening to everybody. Thank you very much for inviting me to uh, provide a short welcome address and also about the book. First, today we are gathered here to uh, listen to the second Justice Rajindar Sachar Memorial Lecture by Honorable Mr. Justice P.S. Narasimha on right to food security. And also we have the small program to release the book by Sri Sanjay Parikh, our colleague here, on the subject Courts and Hunger. So let me first of all welcome Honorable Mr. Justice P.S. Narasimha, who is here to give us the address on right to food security. Sir, on behalf of the Indian Society of International Law, on my behalf, I cordially welcome you, sir, for this function. I will also welcome our Vice President, Mr. Manoj Kumar Sinha, who is going to chair the meeting today, Manojji. And then we have with us Sri Sanjay Parikh ji. His book is Courts and Hunger will be released today. And I'm going to speak for 2 minutes about the book. And then I also welcome welcome the family members of the Sri Justice Rajindar Sachar ji today here, and all the other colleagues and guests who are actually attending the meeting, and also the EC members also who are present here to attend the meeting. So with this small welcome address, let me say a few things about the book. It's going to be very short. So I thought it's the book Courts and Hunger by Sri Sanjay Parikh, Senior Advocate, Supreme Court. This book is published by Vani Book Company. It is unique in many ways. The book perhaps might not have been written by Sanjay ji, but for his passion and something more to deal with this issue before the Honorable Supreme Court, and later mostly at the National Human Rights Commission. As the book title says, it is about understanding the man-made disaster at Kalahandi, Balangir, Koraput, which are known as KBK districts in Odisha. Now these districts have been again in this book in great detail he has given. These 3 districts now have been distributed into more than 8 districts now. They have been expanded. According to the statistics given by the book, almost 30% of the land mass of Odisha is in these districts. Plus, it also has 19.8% of the population living in this area. These are well known. Kalahandi is well known, but they are known as KBK districts for whatever reason, what has happened in the last several decades there. We all respond with a lot of concern to the subjects like poverty, hunger, malnutrition, unorganized labor, and so on. But here in this book, one can see that the aspect of hunger triggers a chord in the author. Just not that. It makes Sanjay ji do something about it. In the introductory part, Sanjay ji explains beautifully and simply about an incident that he saw as a child that made him think about the aspects of hunger. Well, I do not want to narrate that story here now. It is for all of you to read. It's there in the book, or maybe he can tell you later. This part also narrates the context that emerged in the years to come to deal with this issue. His first meeting with Mr. Kishan Patnaik, the Member of Parliament and a social activist from Odisha, in 1989, who took this issue to the Supreme Court and argued in person. The court had issued proper orders and had given liberty to Mr. Patnaik to come back whenever he wanted, actually. And one word about Mr. Kishan Patnaik, because it's again personal to me, most importantly for me. He was an alumnus of JNU as well, and he was quite senior to me. But I know generations of my senior friends and other colleagues activists were inspired by Kishan Patnaik to work in the rural areas, many of whom I have personally known, and some people worked in Madhya Pradesh, some have worked in Odisha, Bihar, and many places. And I don't think Kishan Patnaik is no more. At that time, he was very unwell when he met Sanjay ji. That much I know. And he was also responsible in the starting. He was very active in JNU. They had what is called as Samta Yujan Sabha. That point of time, I can, because I was student at that point of time in JNU. Now, of course, I'm teaching there. So this is my personal anecdote to share with you. And he was one of the legends in that sense. He worked tirelessly and brought these Kalahandi KBK districts to the fore, to the court, and he was dedicated to that. That much, of course, all of us know. But later, of course, it's Sanjay ji who took it over. When Sanjay ji met him in 1989, which of course is in the book. I'm not saying anything out of the book, but only this earlier part which I mentioned is of course out of the book. However, he could not further fight the case. Kishan Patnaik ji told him. As Sanjay ji puts it, I just want to quote, when I met him again, he looked disheartened and said that it would not be possible for him to start the battle all over again. I expressed my wish to take it forward to see to its logical end. This is what Sanjay ji told him. And of course he did. I think I should give an applause for this great thing. The story of this book is just that. Concisely published, this book of about 200 pages has about 10 chapters of varied length. First few chapters provide the history and profiles of the KBK districts, Kalahandi, Balangnar, and then the Koraput districts. It gives the story for almost 100 years with statistics, with details. What are the who actually are the people living there, and all those details. The chapter on the history of famine codes. Famine codes. There are famine codes developed by British that time. Provides us an interesting insight as to how the British and later the independent Indian government of India dealt with the issue of famine. It records in detail the approach and the SOPs to be followed by the successive administrations, which is quite interesting to see. And of course, this was studied by many people later. How these famine codes by themselves became a problem at a later stage is what Sanjay ji explains. He also refers to various writings and sources such as Professor Amartya Sen, Professor Jean Dreys, and several others who worked on this issue. There are many in India, not only economists, others who have been working continuously on this issue. That I think we should take into account. Which Sanjay ji, of course, has references to this in his book. There is a separate chapter on international law and human rights and right to adequate food. This is followed by constitution and the right to food. Later parts of the book deal with the proceedings before the Supreme Court and the National Human Rights Commission. Statistical details, tables, and references add to the authenticity of the book. It ends with a chapter on the road ahead and the continued monitoring mechanism. All the primary documents that include court proceedings and proceedings before the NHRC have been annexed to the book as 7 appendices. So this will be very useful for as a basic source for further research for its students and lawyers and others. It was indeed a long battle of over a decade for Sanjay ji and others, including Rajindar Sachar ji. I think I have seen the appendices where Rajindar Sachar ji, I think, appeared along with him in the initial stages before the Supreme Court. So I think it is a very fitting tribute to Sachar ji, this book as well, actually, because he was one of the active members of the PUCL, and they actually worked together on this case as well. This will be very basic. It was a long battle, so there is indeed no end to this battle. It started around after Kishan Patnaik ji left. Sanjay ji and other agencies, including PUCL, took it over, and it was a long battle of over a decade for them. Generally, first they went to Supreme Court, and then it went to the Honorable Supreme Court directed it to National Human Rights Commission to look at it. And there are people who have worked as special rapporteurs. He mentioned the references made to Mr. Chaman Lal, and there are other people who actually went there and worked with on the ground to see the problem there and how to improve it. Actually, problem is one thing, but how to actually take care of what kind of changes are required. That's what actually the court and HRC particularly looked at it. So I'll just take another minute and finish. There is indeed no end to this battle, but it is heartening to see that the situation in KBK district improved considerably after 10 years of this battle, not only legal battle, but also on the ground to improve the situation, measures taken, and Odisha government also was very helpful in doing this. I just, this is my viewpoint. This, the role of the, what actually I can see from the book is the role of the both the institutions in dealing with the issue over a long period of time in a complementary way is a study by itself of our great institutional framework, both Supreme Court and the National Human Rights Commission. Perhaps this is someone should consider taking this forward, looking at these issues. Actually, the NHRC was that time had Justice M. N. Venkatachalaya, followed by Justice J. S. Verma, and then followed by uh, Anand. I think three very distinguished Chief Justices of our country actually monitored this, and all the records have been mentioned in the book. It's very touching to see how actually they talk about. This is a primary sort of sources. So the perhaps someone should consider. Yeah. So lastly, the book has touching forward by Honorable Justice M. N. Venkatachalaya. It has a forward by him, whom I also knew and had a great sort of a contact. I mean, I knew him also personally well, so I can understand the way he wrote, and which captures the content of the book in one sentence. I just quote: narration of history of the reformative action initiated in the KBK districts by Supreme Court with the assistance of NHRC and his own significant role. These are the three things which Justice Venkatachalaya notes that this book actually contains. And I also must mention that he requested the court and also the NHRC. I remember Sanjay ji himself wanted to go there on his own expense to study the problem, and I think he did that actually. Because he didn't write much about it. I think he should write more about these things. One part about the book, I should say, that he has written only in the first few pages about some personal account about the book, but rest of it is more factual, more informative, and more about the NHRC, Supreme Court, etc. But I would rather want Sanjay ji to write about more about the personal account as to what he felt about it. I'm sure Sanjay ji himself is a poet. He has written 3 volumes of poetry published by Vani Book Company. I can see in the back side of the book. Hopefully, the next book should tell us more about the more not about the about how he actually managed to do this for 10 to 15 years. This will be very important for law schools students who are actually studying law in law universities, because this is where I think our future lies. Students should read this kind of studies, should understand this. There is something more than what actually they are doing to the world. So that's what actually, that's why I want him to write more about the, not only about the procedures, beyond procedures, what he can actually talk about, which he did in the initial chapter. This is the only discontent I have, and I wish he can only resolve it only by writing another book, perhaps, and he should do it. And lastly, there are many such stories. Of course, Supreme Court, of course, we have Honorable Justice Narasimha here. Supreme Court, I am sure, has done not just, I think they have monitored several cases. It's a great institution. They have really sustained our access to justice issues. This is a very important access to justice issue. KBK districts, the people there, they have no access, they have no idea, but they have been, part of our country. But the court, Supreme Court and the NHRC effectively 10, 15 years have transformed the districts up to a point with the help of the government, and it is possible. That is what actually, it's a very positive story, that I must say. So we have a book here where I just end by just quoting from the Sri Justice, the Honorable Justice M.N. Venkatacharya has forward the last words. After that, of course, so I quoted it, but Sanjay ji has a chapter on way forward, of course. I will end by quoting his, words. One is, he feels that this is need to be told. That's one. Second, he suggests that this is a model that is workable, that you can go to court, and concludes that in contemporary world, right now, the model which was adopted in the last, the way they went about transforming this KBK districts through various court orders, various NHRC studies, etc., which Odisha government implemented, that statistics are available. So, having looked at that, he feels that in the contemporary times, whether it is the problem of migrant workers or the shortage of medicines during the COVID pandemic, a structured approach which is transparent and fixes accountability with periodical checks can, to a large extent, control the situation. So this is what, there are of course many other things, but I think this is the crux. You have a model, you can actually work it out, and then this can be taken forward. I think the book has these ideas, which is an extremely important contribution, and title itself is a very unique in that sense, Court and Hunger. We have so many books written on the court and many things. Of course, we mostly look at more profitable avenues, but here is one book which actually, from the legal community, provides an insight into something extremely useful, interesting, but most importantly to the people. I think with these few words, I introduce the book. Once again, welcome all the distinguished dignitaries, particularly Justice Narasimha, for this program, and thank you very much.
Thank you so much, sir, for your introductory remarks and for sharing the brief synopsis of the book. Now I invite Professor Manoj Kumar Sinha, sir, to kindly give his comments on the book.
Honorable Mr. Justice P.S. Narasimha sir, Judge Supreme Court of India, Sri Sanjay Padik, Senior Advocate Supreme Court of India, Professor V.G. Hegde, Professor of Law and Chairperson of Center of International Legal Studies, Sri Dr. Shikhar Ranjan, Secretary General of Indian Society of International Law, Professor Johar, and all dignitaries of the dais, and of course the family members of respected Justice Rajindar Sachar sir. Now, if I go by the issue which I have to speak, Hegde sir has speaks remarks about the book and comments on the book. So comments, I'm little bit confused what comment I have to do, but let me start with the sir very nicely elaborated about the book, how book has come. But I must take a credit from Sanjay sir. The thought about the book, I believe some way, रोटी पर चर्चा करते करते हमने कई बार इस बात पर कही थी आपसे, जो हमारे सर के घर पे खाते खाते मैंने बहुत रोटियां सर के यहाँ तोड़ी हैं और सर के कितने रातें गुजारे हैं, और ये सारे बुक्स को मैंने पर्सनली हाथ से ऊपर में हॉचकस के घर पे जाके सर के घर पे बैठ के और लिखा, और आई एम वेरी हैप्पी दैट सर टोल्ड मी कि सम ऑफ योर नोट्स आर स्टिल देयर which you have noted down. So I gone through all these things, and just I returned from England, I realized the importance of economic, social and cultural rights. The importance of economic, social and cultural rights were never recognized the way civil and political rights have been focused, and that is an unfortunate development. It took place in the constitution, and that also took place at the international level. I'll come back to those parts little bit later. उससे पहले कुछ चीज़ें होती हैं जो हमारी ज़िंदगी में बड़े ही, और हम लोग का ऐसा सौभाग्य रहा है. सो आई फील वेरी ब्लेस्ड कि वी हैव सीन पॉवर्टी फ्रॉम दी क्लोजनेस, गरीबी को एहसास किया, भुखमरी को देखा है, और कई बार ऐसी महसूस करते हुए लगता है अपनी भी और दूसरों को भी. जब you once you feel, then you start realizing, and this is the reflection which Professor Sanjay Parekh, which he witnessed a girl who was like searching for some food on the outside of the garden, and then subsequently he made. So that is the reason this reflection and this has come in a form of book. So जब आप इस चीज़ों से गुजरते हैं और इस चीज़ों का आप अनुभव करते हैं, तब आपको पता लगता है कि संविधान एक तरफ, सुप्रीम कोर्ट के जजमेंट एक तरफ और एक ग्राउंड रियलिटी एक तरफ होती है. सो यू फील कि व्हाट आर द चैलेंजेस आपको सामना करना है और किस तरह से इम्प्लीमेंटेशन करनी. We are very fortunate. We can go back and see that starting from the judgment of the, I think the Lordship Champakam Dorarajam versus the State of Madras, where Supreme Court of India has said that Part 4 has to run subsidiary to the fundamental rights. Of course, the subsequently M.H. Qureshi, Kolaknath, Vaman Rao, and other harmonious conflict construction integrated approach has been, and even in Puttuswamy judgment, which Sir has cited, that relationship between civil and political rights and economic, social and cultural rights under paragraph 262 you have mentioned in your book also. So we see the court over the years have also looked into. And when you look deeply under the Article 37 of the Indian Constitution, it has three important elements. It says the first is a non-justiciable. Second, it says fundamental in governance in the country. And third, it talks about the state should make a law for the implementation. So some way implementation is very much there, but lack of resources, lack of programming, it has been made non-justiciable, and its implementation requires program, policy and resources. That is big consideration, and that is the reason it has been in Part 4. But if I compare the development which has also taken place at the global level, the same time where our constitution was in the process of completion or drafting, the same time another milestone at the global level which has taken place, the adoption of Universal Declaration of Human Rights. An Universal Declaration of Human Rights is an instrument which contains civil and political rights, or what we can say Part 3 of the Indian Constitution, Part 4 of the Indian Constitution and Part 4A of the Constitution, only in 30 articles. 30 articles under this Universal Declaration of Human Rights. You see, when they drafted, including India participated in the drafting of Universal Declaration of Human Rights, and Hamsa Mehta, who was representative, she was representing India. There was no opposition, because the members and also states thought about it's going to be a non-legal binding instrument. That was the Universal Declaration of Human Rights. But the moment they moved to the second stage, drafting of legal binding instruments, and that has created a lot of issues to which rights should be given priority, like fundamental rights, right to life, liberty, equality, all these, or right to food, right to housing, right to clothes, right to social security, all these aspects. Unfortunately, international level also, it has been bifurcated. And Lordship, you will be surprised to know that when we adopted International Covenant on Economic, Social and Cultural Rights in 1966, it did not have an effective implementation mechanism. They said, no state should complain, no individual should file complaint. So it was made renderless without enforcement mechanism, which was filled in 2008 after number of years, on the 60 years of the adoption of the Universal Declaration of Human Rights. Now there is a mechanism there, enforcement body is there for the enforcement of economic, social and cultural rights. Why I am saying all these things? Because this book contains this part, one of the chapters, like Sri Sanjay Parekh has mentioned, and there he discussed about the human rights in the international perspective. Sir, broadly in his book has covered, let me just quickly, I think Lordship, we all are here to hear the Lordship, so I will not go on. Teacher has a problem, Lordship, अगर हम उनको माइक देते हैं तो वो माइक के पीछे इस तरह से पढ़ते हैं कि बच्चे चले जाए वो छोड़ते नहीं. so Lordship, so I'll just be very brief and quickly finish, but I'll just summarize quickly by saying few words. जैसे इसमें कहा गया, सर ने एक प्रोफाइल ऑफ केबीके डिस्ट्रिक्ट ही हैज गिवन एज हिगडे सर, पॉवर्टी एंड फेमिन कोड्स के बारे में डिस्कस किए हैं, हिस्ट्री ऑफ फेमेन्स के बारे में डिस्कस किए हैं, और इंटरनेशनल लॉ एंड कॉन्स्टिट्यूशनल लॉ पर्सपेक्टिव also sir has discussed. And sir has also highlighted many of the important Supreme Court judgment in this particular book. So book is in a beginning. I'll not say, and this we have to avoid. Lordship, with all due respect, I feel as a law student or law teachers, and even we see everything in only one angle. कानून के हिसाब से देखते, लॉ के हिसाब से, but it belongs to everyone. This book is not only for the law students, it belongs to the history students, it belongs to the sociology students, it belongs to a common man. आम आदमी भी इसमें पढ़ के अपने बारे में कुछ जानकारी हासिल कर सकता है. So a subject is not monopolized by one particular stream because it has been written by a lawyer or it has been written by a writer. So the book which has been written by a lawyer, it should be read and made available to all to understand what is the content, because the language which is very easily, I believe, anyone can read, anyone can understand, and everyone has a duty. Everyone has a duty to see that if things happening bad, they can also play important role. Let me conclude with this. I believe that sir, you took long time to bring this book. We started journey from 1997, and that has been culminated. So even the process is little bit slow with the drafting of international treaties. Like we have failed to draft United Nations Convention, any convention on terrorism. So the failure of international community has failed to draft an international convention on terrorism. So till date, and India has like in 2002 sponsored a draft, but it's still international community. But I'm very happy that sir has ignored that development, and in 2022 he brought a book on an occasion where जस्टिस राजेंद्र सच्चर की मेमोरियल डे में पुण्यतिथि के समय लाया गया है. और मैं एक और लास्ट बात कहता हूँ जो सर से थोड़ी पर्सनल लेवल पे है. रोटियाँ तो बहुत तोड़ी, खाना भी बहुत खाया, और वो उन समय खाया जब इसमें अभाव होती थी. मैं सिस्टर के पास रहता तो मुझे लगता है कुछ दिक्कतें होती थी, सर ने मेरी मदद करते थे. और मैं जो भी हूँ, कहीं ना कहीं संजय जी का बहुत बड़ा योगदान है पर्सनली, और इसको मैं एक्नॉलेज करना चाहता हूँ. मैं उन बातों को बहुत ही, उन रातों को मैं याद करता हूँ जैसे सर होते थे और मिसेज भी, भाभी जी भी होती थी, तो उन्होंने काफ़ी मेरे मनोबल को बढ़ाया. और वहाँ उस दशा में जहाँ जॉब की सर्च थी, सारी चीज़ें वो करने के, और उसके बाद इन्होंने मुझे एक तरीके से प्रोजेक्ट किया जस्टिस राजेंद्र सच्चर जी के घर पे भी कि मनोज को ह्यूमन राइट्स की कुछ जानकारी है. और सर हमेशा जब भी रहते थे तो फ़ोन करते थे, मैडम आपको बताते हैं, मैं कई बार आपके घर पे भी गया हूँ, तो सर फ़ोन करते थे, मनोज वो कल मैटर लग रहा है, 4-5 आर्टिकल निकालो कहीं से. तो मैं जल्दी से खोजता था और दे देता था. तो उससे मेरी एक इमेज बनती थी कि ये लड़का करता है. मुझे बाद में पता लगा मैं उस सर्किल में फंसा हूँ. अच्छा करने से फंसते भी हो, तो ये भी बात है, लेकिन वो बहुत ही इंजॉयमेंट होती है. और इन्हीं से बातें सर के आपके बहुत बहुत आभारी हूँ, सर का भी और संजय जी का. सो आई एम वेरी फॉर्चुनेट दैट आई शेयर्ड माई थॉट in presence of Honorable Justice Narasimha sir, and we all are looking forward to hearing. Thank you very much.
Thank you so much, sir, for giving insightful address and sharing your experience. Now I would like to mention here that publisher of the book, Ms. Aditi Maheshwari, Executive Director, Vani Prakashan Group, she couldn't join the occasion due to some personal reasons, but she has shared her speech in writing with us, and with the permission of all, I would like to take this opportunity to read her comments and views on the book. With your permission, sir. Thank you. Honorable Mr. Justice P.S. Narasimha, Judge Supreme Court of India, Shri Praveen H. Parikji, President ISIL, Professor Manoj Kumar Sinha, Director Indian Law Institute, Professor V.G. Hegde, Chairperson Center for International and Legal Studies, JNU, Shri Sanjay Parikji, Dr. Shikhar Ranjan, and all the dignitaries, I extend my greetings to all of you from Vani Prakashan. We from Vani Prakashan are extremely happy that the book Courts and Hunger by Shri Sanjay Parikh, Senior Advocate, is going to be released today. I apologize for not being able to attend today's function due to some personal reasons. Shri Sanjay Parikh has argued several important public interest matters pertaining to human rights, civil liberties, and environment, which I am sure you all must be aware of. I don't want to list them here. He raised the chronic problem of starvation deaths in KBK region of Odisha, having 8 districts, both before the Supreme Court and the National Human Rights Commission, a legal battle which took nearly a decade. In a simple and concise manner, this journey has been brought out in the book. It sheds a spotlight on the KBK region and the legal struggle with this man-made disaster. This book opens watersheds of information about the court proceedings that led to a historical change in this region of Orissa. We hope that the book is read by scholars, law practitioners, and general readers too, so that awareness about this struggle travels far and wide, and that similar efforts are made by the state in the regions which are facing the human problems of deprivation, hunger, and deaths. On this occasion, we are also thankful to Medha Patkarji and Professor Yen Reyes to have endorsed the exquisite research and tireless work of Sri Sanjay Parikh as his publisher of other books, taking human rights forward, People's Union for Civil Liberties Judgments, and his poetry collections, धूप में छिपे शब्द, तुम हो तो हूँ, and कुछ ना कहो, इस सांझ. We at Vani Prakashan Group are honored and equally amazed to learn about the humane side of Sri Parikh. As Swami Vivekananda said, karma is the eternal assertion of human freedom. We wish Sri Parikh more strength in his pursuits of freedom for society and for the youth of forthcoming generations. Thank you. Thank you so much. Now I invite Sri Sanjay Parikh sir to address the gathering and to give introductory remarks on Justice Rajindar Sachar ji.
Honorable Justice P.S. Narasimha, Judge Supreme Court of India, Professor V.G. Hegde, Chairperson, Center for International Legal Studies, JNU, Professor Manoj Kumar Sinha, Director, Indian Law Institute, Dr. Shikhar Ranjan, Secretary General, ISIL, Sri Sanjeev Sachar, Madhvi Sachar, members of the bar, colleagues and friends. My good friend Professor Ramanujan was Pro-Vice Chancellor of IGNOU is sitting here, and I said whether I speak about the book after two speakers have introduced the book, and he said don't speak too much because it has already been introduced. So I will not actually talk about the book because we have assembled here for Justice Sachar Memorial Lecture, the second one. But I would like to say two things. Number one is, I am touched by the sentiments which were expressed by Professor Manoj Sinha, and as he mentioned, he acknowledged, I also acknowledge that whatever I know about international law is because of him. The book, I'll only say, was a dream, dream which I saw as a child, and all of us have those dreams, and we try to realize them when there is potentiality, when there is something in you, and there is an institution in which you are working. To try to do something. It may be a legal institution, it may be an educational institution, it can be any other institution. But realization of the dream, if you have, then I think the entire purpose of your being there becomes meaningful. Otherwise, it becomes an exercise of acquiring information or earning money, and that's all, nothing more than that. The other thing is that, surprisingly, there is another aspect which we must know, that how the commitment happens, and the commitment comes, according to me, is some concept of knowledge by identity, that you identify yourself with the issue. You put your entire self into it, and once you put your entire self into it, what a person sees actually with the physical eyes cannot do that which your vision can really achieve. That's another thing, and we must understand, all of us who work and take up the human causes, public causes, should have that in mind. It's not the physical one which is important, it is your internal eyes, what you see inside you, which is important. Now, I would not like to say more things about the book because we have to proceed with the Justice Sachar Memorial Lecture. So, as I am welcoming Justice P.S. Narasimha, Judge of the Supreme Court of India, I am grateful to him for readily agreeing to deliver this lecture and to release the book. In spite of his busy schedule, the first Rajindar Sachar Memorial Lecture on Human Rights, Concerns and Challenges was delivered by Justice Madan B. Lokur on 10th of December 2019 due to corona pandemic. The continuity of these lectures was disturbed. We hope to continue with these memorial lectures regularly in the future. I thank ISL, its President Shri P.H. Parekh, who could not come today because of personal reasons, and office bearers for their decision to include Justice Sachar Memorial Lecture as a part of its regular annual event to recall Justice Sachar's immense contribution and commitment to the cause of human rights and civil liberties. The other annual event being V.K. Krishna Menon Memorial Lecture for Shri Menon's contribution in the field of international law. Though this audience is familiar with immense contributions made by Justice Sachar, still I think it would be befitting the occasion to remember his works and to say a few words about him. Shri Sachar was born in Lahore, present day in Pakistan, on 22nd December 1923. His entire education, including law, took place in Lahore. His father, Shri Bhimsen Sachar, a veteran freedom fighter, was the first Chief Minister of Punjab immediately after the first general elections took place in 1952. Later, he became Governor of Andhra Pradesh and thereafter High Commissioner for India to Sri Lanka. Shri Bhimsen Sachar suffered detention due to his strong opposition of emergency in 1975. Shri Rajindar Sachar had a successful career as an advocate in Punjab High Court. He was president of the High Court Bar Association from 1967 to 1968. He earned a great name and reputation as an advocate. Thereafter, he was appointed as judge of the Delhi High Court in 1970. Later, he was transferred to Sikkim as the first acting Chief Justice of Sikkim High Court after the High Court was set up there. He also served in the Rajasthan High Court for some time before he finally returned to Delhi High Court, from where he retired as the Chief Justice in December 1985. During his tenure, he headed one-man inquiry committee to inquire into the air crash in 1973, in which Mohan Kumar Mangalam, the then Union Minister for Steel, had died. In 1977, he chaired the High-Powered Committee to review the Companies Act and the MRTP Act, which acts were amended accepting his recommendations. In 1984, Shri Sachar reviewed working of the Industrial Disputes Act. Among other achievements was his being the member of UN Subcommission from 1990 to 1994 on the prevention of discrimination and protection of minorities. He also worked with the UN Commission on Human Rights on the right to adequate housing and had submitted a report on right to adequate housing at Geneva. He was the trustee of Servants of People's Society and Gandhi Smarak Nidhi. He actively practiced as a senior advocate in the Supreme Court from 1986 till 2017. Among several important cases he argued are the cases relating to mandatory declaration of assets and criminal antecedents by MPs and MLAs, none of the above nota option in elections, against surveillance and phone tapping, and against amendment in the Representation of People's Act, removing the domicile requirement in Rajya Sabha elections. He was closely associated with Dr. Ramanohar Lohia, Jayaprakash Narayan, and Madhulime, among others, from an early age. His attachment to People's Union for Civil Liberties, PUCL, of which he was president from 1986 till 1995, was remarkable. He contributed a lot to strengthen the organization. I remember that in public functions, he always preferred his recognition as being a member of PUCL rather than as former Chief Justice of the Delhi High Court. He became popular when he submitted the report on social, economic and educational status of the Muslim community in India as chairperson of the High Level Committee. The report emphasized on the growing social and economic insecurity and disparity which Muslims faced since independence. He was a regular contributor on all current social, political and legal issues which regularly appeared in prominent newspapers. He passed away at the age of 94 on 20th April 2018. His son Sanjeev, daughters Madhvi and grandchildren survive him. My association with him after his retirement in 1986 for more than 3 decades is still vivid in my memory. Probably it was the best part of my professional career. We worked together on so many cases of public importance, traveled together as members of People's Commission to record the testimony of poor tribals and farmers on the oppressions and exploitation they suffered. We fought many PUCL cases pertaining to electoral reforms and for protection and promotion of human and constitutional rights. This was not merely the association which enriched me in diverse ways, law being its small component, but in viewing the life differently, to think and observe one's relationship with the other, a selfless pursuit, a concern arising from within for those who suffer inequality, man-made or otherwise. I suppose the book Coats and Hunger is the result of such a concern. I am ever grateful to him for what I learnt in his association. He was extremely humble and polite, but when occasions came to show his dissent, he was emphatic and strong. He was affectionate and sensitive in human relationships. His association was a blessing and an asset which I ever cherish and remember. In his autobiography, In Pursuit of Justice, Justice Sachar has narrated many stories and anecdotes. One incident is quite interesting. In 1955, when his father was Chief Minister of Punjab, Pandit Jawaharlal Nehru was invited to have breakfast at their residence. Full of socialistic ideas and opposed to certain policy decisions of Pandit Nehru, Sri Sachar politely told his father he will not join them for breakfast. It thus ended in Sri Sachar not meeting one of the greatest leaders of India. He later felt that it was childish, but called it as his youthful, genuine and unshakable faith in socialism, faith in social values, which he continued to have till the end. Another instance of his independent thinking was his taking up cases of human rights violation and illegal arrests against the government headed by his father as the chief minister. But credit also goes to his father, who appreciated his son for being sensitive towards such issues. In the book, he narrates another interesting incident. During emergency, both his father, that is to say, Shri Bhimsen Sachar, and his brother-in-law, well-known journalist Kuldeep Nair, were arrested. His father was initially taken to Tihar jail, where Kuldeep Nair was already lodged. He thought that his father-in-law had come to take care of him to see whether he was all right, but got a shock when Sachaji's father affectionately told him, "Beta, dear son, I have come to give you company." As a judge of Delhi High Court, he took up many bold stands. One such being questioning of all cases of attempt to commit suicide pending in different courts, most of the cases being against poor laborers. Later, Supreme Court affirmed the law. In public meetings where human rights issues were discussed, he was always in the forefront. People awaited for him, fondly called Sacharji by the masses. His absence, a vacuum, a void, is felt more by everyone in the present atmosphere. Late Shri Solis J. Sorabji rightly said, Justice Sachar's fight to preserve the secular fabric of India continued till the day he passed away. With this introduction of Justice Sachar, let me introduce to you this evening's speaker, Justice P.S. Narasimha, Judge, Supreme Court of India. He was elevated directly from the bar on 31st August 2021, which is a rare recognition and honor. Born on 3rd May 1963 to Srimati Satyavati and late Justice P. Kodanda Ramaya in Hyderabad, he graduated with triple majors in economics, political science and public administration from Nizam College, Hyderabad, and pursued law at the Campus Law Center, Delhi University in 1988. In the same year, he was enrolled as an advocate and practiced before the High Court, Civil Courts and Tribunals in Hyderabad. He later shifted his practice to the Supreme Court and appeared in a large number of cases, including before the Constitution benches. He was designated as a senior advocate by the Supreme Court in the year 2008. As a senior advocate, he appeared in many public law cases involving constitutional, administrative, and environmental issues. He is specialized in laws relating to telecom, competition, electricity, and other regulatory jurisdictions. He was amicus curiae for the bench hearing forest matters. He was appointed as the Additional Solicitor General of India in 2014. In that capacity, he appeared in several landmark cases, including the NJAC case before the Constitution bench. He also appeared in the Ayodhya title dispute matter. He was part of the Indian Supreme Court delegation to the Canadian Supreme Court, where he presented a paper on extradition and environment. He had the rare opportunity of leading the Indian team and represented India before the International Tribunal for the Law of Sea in Hamburg, Germany. He also represented India before the Permanent Court of Arbitration, Hague in Investment Treaty Arbitration. He is part of the governing body of National Legal Service Authority of India and closely associated with the Mediation and Conciliation Project Committee of the Supreme Court of India. As a law officer, he was instrumental in constituting and being part of the High Powered Committee, suggesting sweeping changes to the Arbitration Act and proposing a mechanism for institutional arbitration. He was a member of committees relating to restructuring of all appellate tribunals and reviewing the legal regime concerning corporate social responsibility. He has also been a member of the Investor Education and Protection Fund Authority. Supreme Court appointed him as a mediator in the BCCI case. He could successfully mediate between the members and the board for holding elections and the constitution of an elected body. He had been on the executive council of many national law universities and other educational institutions. He was elevated as a judge of the Supreme Court of India directly from the bar on 31st August 2021, which I mentioned earlier. He will take over as CJI for over 6 months from October 2027 to May 2028. I would like to share a few words on today's topic. I will be brief. Poverty and hunger still prevail. Hunger causes poverty. Poverty induces hunger. It's a vicious circle. Humanity should be free from hunger, food insecurity, and malnutrition. It's a basic human right. But mindless acquisition of fertile lands, developmental activities eroding the fragile and meager resources of livelihood of the tribal and rural poor, resulting in destitution, unemployment, and hunger, social and political systems allowing exploitation and rampant corruption, inhibiting access to food, are all factors which trigger hunger and food insecurity. Good governance and constitutional compassion in a democracy by all wings of the state can reduce these sufferings to a great extent. At least causes which are man-made can be redressed, which we saw actually in KBK, a district example which I have mentioned in the book. Sustainable Development Goals aim at creating a hunger-free world by 2030, a laudable and ambitious goal indeed. But climate change is a big threat which mankind is facing today. It is affecting water, land and environment. Excess heat, excess rain, drought and other phenomena are causing human displacement and breaking down the food systems. Food security is under grave threat. Is this disaster man made? That's the question. The debate is whom should we blame? Rich countries, people living there, all of us, or those who control the power and decide on the choices we make. We have to decide it before it is too late. Survival of humanity itself is at stake. Without elaborating much, I would end by saying that our honorable speaker will enlighten us on this crucial issue of great importance and relevance today. Thank you very much. I should have actually, in the beginning itself, should have paid my respects to Justice Saman Venkatchalaya, because he was the presiding judge who structured the entire proceedings. I would like to also thank Sri Chamanlalji, who was special rapporteur, who visited these places and gave very important suggestions. I must also thank my colleagues who helped me, Mr. Avinash Mishra, Sir Shanmuga Patro, Piyush Mohapatra, Ninni Suzanne Thomas, Mon Shri Pathak, Sanjana Shri Kumar, Dr. Claude Alvarez, and Professor Manoj sitting here, Aditi and Aruneshri, who helped me, who are the publishers of this book. Thank you very much.
Thank you so much, sir, for your insights on the contributions made by Justice Rajindar Sachar. Now is the time to release a book titled Courts and Hunger, authored by Sri Sanjay Parekh. I would request Honorable Mr. Justice P.S. Narasimha sir to kindly release the book and all the distinguished guests on the dais to join. Many congratulations, sir. Now I am privileged to invite on podium Honorable Mr. Justice P.S. Narasimha sir to deliver second Justice Rajindar Sachar Memorial Lecture on Right to Food Security. We welcome you, sir.
Thank you very much. At the outset, Sanjeev Sacharji, Madhavi Sachar, the star of the day, Sanjay Parekh, Mr. V.G. Hegde, Mr. Manoj Kumar Sinha, Mr. Shikhar Ranjan, distinguished professors, lecturers, senior counsels, advocates, my dear friend Sheshagir Rao, and my pranams to our elders. I was actually very delighted when I was requested to speak on the occasion for two very reasons. One is because the book authored by my dear friend Sanjay Parekh on courts and hunger is a whiff of fresh air. These days, in the hustle bustle of profession and the number of kind of cases that the courts are involved, we have only lectures, seminars, and speeches on either on international law or arbitration or IBC or matters such as some commercial contracts. It seemed rather an eroded thing that we are still remembering one of the most essential part of our civilization and living, when we will have to talk about an issue which continues to trouble us, that is the hunger of our brethren. It didn't take even a second for me to immediately accept the invitation. I am very glad to be here amongst you on this occasion. In his biography of Mahatma Gandhi, Louis Fischer has said that most of us are like him. Whenever troubled situation arises, we react in the same way as Gandhiji does. And there is nothing different from the way he would have acted. He points out one point of distinction, that is, when he saw something wrong, he stood up and did something. It's nothing unusual for most of us to see death or see hungry people. But the incident in Sanjay's book, which he narrated, a hungry woman being there and he saw her, created a kind of a sensation in him, and he internalized it and carried it with him till date. And that is how that thing got translated into the book. It is the thought which matters, and it is the will of a person. It's exclusively the will of the person that translates the thought into action. And I congratulate him for not only being sensitive like many others, but to take it forward and try and see a solution to it. I also remember yet another incident when Gandhiji had gone to West Bengal for the first time, and people insisted that he go and see Kalibadi, the Mata temple there. And as he was about to enter, I believe he saw large number of lepers there, and he didn't even enter the temple. And he called for a bus, organized for a space where he can start a shelter for them, and shifted all of them there. And that happens to be the India's largest shelter home for the lepers. This again is yet another incident where I am sharing with all of you that how the action that follows a thought which enters one's mind matters so much for change in the society to be brought about. The another reason which I was indicating is, I remember Rajindar Sachar ji. We used to be seeing him regularly in our Supreme Court canteen. A very cheerful man, extremely dignified man, and in his Bandgala long sherwani. He was a firefighter in the court. He would come back, forget about everything, sit with friends, chat, have his cup of tea, very courteous to youngsters. His picture is very vivid in my mind, and I am again grateful for inviting me to speak today on a topic which is so very important, so relevant, so compelling, and which is perhaps the very purpose of our constitutional governance. Without being the speech being in the form of a lengthy narration of case law and other things, I would want to share some thoughts with all of you. The story of Supreme Court, particularly in the context of hunger, is, I think, episodic. It is perhaps in two phases, and I think the time has come for the Supreme Court to take it to the third phase in the context of right to hunger. When we speak about hunger or right to food, we are talking about the need for food and not a want. and even that need is not being provided to all, and that's a matter of concern. There are studies with respect to whether there is sufficient food or not, which is an issue of economics. There is enough number of articles which say that the world has sufficient food to feed everybody, but then it's a question of entitlement which troubles the way of distribution, and the economic process marginalizes many number of people to become hungry and perish. Interesting part for us to consider today is the place that hunger or right to food in the Constitution. When we declare, we the people solemnly resolve to provide for all of us equality, liberty, and fraternity, there is no reference to a right created or an establishing or a solemn resolve to ensure that nobody goes hungry. And that's not the way the Constitution is to be read. When we say we the people, it takes within its sweep the obligation not only of the state but also of the individual and also of the society and the members to ensure that a brother and a sister doesn't go hungry. Going beyond the preamble and to search where exactly is this right created, we have in the directive principles certain endeavors of the state to ensure that there is equality in employment, there is a right to work, and the state shall endeavor that there are means by which somebody is empowered. When we come to fundamental rights, most important part of fundamental rights, yet again you would not see any right being created with respect to a person, but then all that we have is right to life. There is no doubt about this fact that right to life will definitely include the right to food. Nobody will even doubt that. But then the first phase of the Supreme Court's consideration of this very important issue arose in a series of judgments where it expanded this expression, life, and declared it that it shall also include the right to food. There are a series of judgments. I will cut that short. It's not necessary for us to recount all those. But then the problem didn't stop there. That declaration that there is a right of an individual under our Constitution to have a food being provided to him, to her, did not really help the situation, because that right, even after recognition, merely became a declaratory. A right by itself would not have provided a midday meal to a person. So the first phase was rather recognition and declaratory in nature. So one had to proceed further. And a stage 2 came when the court realized that it is not sufficient here, and unless we put in some kind of an obligation on the state, the declaration itself will not be sufficient. It is in the second stage that cases such as PUCL, where the court not merely recognized the right but also recognized an obligation of a state to ensure that hunger deaths won't occur or that food is provided to individuals. This happened in a couple of cases, and sporadically there are some more instances which we don't need to recount today. One or two cases were followed up over a period of time as they invented yet another methodology of continuous mandamus and ensured that the state would go on and finally come back and report to the court that it has been accomplished. The question today for us is this sufficient enough? Even that additional step in the second phase has not solved the problem. And it is at this stage that we need to recount yet another situation. That is, it's not merely in law, it's not merely an issue of law, it is a combination of economics and legal principles which would determine the position of a person who needs to be catered to, a person who is hungry, his rights and his entitlements. The economic aspect of it has been researched enormously. Large number of factors got contributed to the situation where the world is today. It is now more or less clear that it is not a production issue, production of the food grains, it is the distribution of the food. Today, if we don't go very jurisprudentially or theoretically, issues such as distribution of food grains across the country, the procurement policies, the pilferages, the corruption in food, the wastage, lack of efficiency, and many other such issues have been talked about, discussed, are economic issues which contribute to this unfortunate situation of many of our brethren going hungry. Today we will have to discuss another issue which is parallelly contributing to the problem, and that relates to the legal issue. And we can discuss that in two parts. One is about entitlement, which has trappings of legal aspects of it. And apart from entitlements, it is also the duty orientation. Constitution, our constitution in particular, is primarily right-based. Primarily, it prevents the state from encroaching the most precious fundamental rights of the citizen. The vocabulary of the court, also on the basis of the constitutional provision, had always been right-based vocabulary. There needs to be a change in the vocabulary and the usage of the expressions, the interpretation, as to how the constitutional provision can now be interpreted in a manner where there will be imposition of the state on the state, an absolute and clear obligation. On the first part of it, relating to entitlement, it is primarily by the provisions that are made by the state, by the government. The provisions by the state will be by way of empowerment, and secondly by way of provisioning the basic needs. So far the provisioning of the basic needs are concerned, Parliament has passed statutes as per which the Food Security Act, as per which individuals who are in need are identified, obligations are created, systems are created, methodologies are provided. These targeted individuals who are below the poverty line are given a right under the statute, which there is a need on the part of the state, and there is also a correlative obligation on the part of the state to ensure that these provisions are met. Having
passed the act, and having worked on the act for over years, it was realized that it is not sufficient, it is not working efficiently, and therefore an alternative methodology of provisioning, of empowering through money, has been adopted. These two together operate today as the statutory and the legal regime to ensure that food reaches those who are below the poverty line, and they can claim it as a matter of right. Where does the court come in there? Where does the right come in there? Today, if we are dealing with a power that will be vested in the hands of persons who are hungry, the search must be for a provision of law or a right under the Constitution, where one could go to the court and ask for such a right. The first phase, the court recognized a negative right. In the second phase, the Supreme Court has tried to bridge the gap by saying there is also an obligation. In the third phase, which is to commence, and perhaps commenced a little bit, is in enforcing these statutes. These are the statutes which grant a provision, the basic need in the form of food in the statutory framework. It also provides the empowerment through direct transfer methodology. Like any other statute, like labor laws and many other statutes, they are on the book. So the role of the court comes in enforcing these and ensuring that the parliamentary promise to the citizen is carried out by the executive, and therefore the rights which are contemplated in the statutory provision must be carried forward. That is the most essential part of it, which perhaps the time will tell to what extent we all have contributed and the courts have taken the next step. The yet another, the parallel issue which is also a matter of concern and which is also seminal for the present purposes, moving away from what's called a negative right, and as we are saying, a duty orientation. There 4 or 5 principles will emerge where the court will have to ensure that the obligations are carried out. New methods, new systems, new principles need to be evolved to ensure accountability. It's not merely the rights that are declared. It is not merely the obligations that are declared. It is now the stage where once these are statutorily pronounced, rights are created, courts will be entitled to enforce it, and enforcement requires, most importantly, what may be called as accountability principles. We can stop here so far as the legal regime is concerned. I'll conclude by saying that there is yet another small aspect of it which we all need to reflect on. Civilizationally, is it always a situation where it is just the obligation of a state to provide and for the court to enforce such obligations? I think as a civilization, so far as Indian subcontinent is concerned, it was not considered to be a state's obligation. Across the board, individually, in groups, in communities, in religious congregations, this country had always witnessed a situations where it was thought of to be an obligation of an individual as well as the society to ensure that there are no hungry persons. That obligation, I think, must have a recognition. And it's going to go a long way if these institutions are strengthened and these institutions are recognized and individuals are motivated, groups are motivated, religious congregations are motivated to ensure that this problem is resolved. I have dealt with in a very limited and a practical point of view. I have not dealt with the rights as enshrined in international law. I am sharing with you things which we can do, as what my friend Sanjay Parikh has done, what lawyers can do, what judges can do, what executive can do. So far as the executive is concerned, it has to implement the parliamentary mandate. Laws are there. If the right to security, a Food Security Act is implemented substantially, we will be able to do it. Courts have to implement it. Courts have to ensure that it is implemented. Accountability is brought about. So far as the future projection is concerned, how the life would be in years to come because of climate change is a very large issue. We need to definitely reflect upon it. It includes many things such as changing our eating habits. Like, for example, moving away from enormous water consuming rice production to more healthier cereals and millets. From change in the life structure, life balance, we need to move on to bring about large number of changes, not only to ensure that the people don't go hungry, but also ensure that we have a better life and better society and better world in times to come. I thank all of you for giving me an opportunity for speaking on this occasion. Thank you very much.
Thank you so much, Your Lordship, for being so kind in accepting our invitation and taking out time to share with us your knowledge, thoughts, and insights on the subject. Your Lordship, we look forward your kind presence in future programs also. Thank you once again. Now I would like to hand over the podium to Dr. Shikhar Ranjan Sir, Secretary General, Indian Society of International Law, to propose formal vote of thanks.
Thank you very much, Dr. Kanika, for giving me the podium. Namaskar and good evening to all, both who are present in person here. I am personally grateful for your kind presence, and hundreds of people have joined us online through YouTube and Facebook Watch. We are very grateful to all of them who have joined us through the virtual world also. It is my proud privilege to propose a formal vote of thanks on this occasion. Honorable Master Justice P.S. Narasimha, Vice President Professor Manoj Sinha, Shri Sanjay Parikh ji, Professor V.G. Hegde, Professor D.N. Johar, who has come all the way from Chandigarh to be with us on this occasion, Professor Rashmi Salpekar, Captain J.S. Gill, members from the bar, colleagues from the Legal and Treaties Division, students of Academy, and all the distinguished gathering. Dr. Meera Shiva is also with us, all the life members, distinguished life members, ladies and gentlemen. You all are here and very well know of the work which the Indian Society of International Law, established way back in 1959, has been doing towards the promotion and dissemination of international law. The society is indeed indebted to its founding president, V.K. Krishna Menon, and his successors for nurturing it as an institution, and that has led us to attain being the premier national institution for international law teaching and research and dissemination in the country. Sir, let me first of all thank eminent jurist and the doyen of human rights movement, late Justice Rajindar, Sachar, in whose memory we are meeting here. The idea of organizing this lecture was conceived jointly with the family of Justice Sachar. Madhavi ji and Sanjeev ji has joined us on the occasion, and along with Mr. Sanjay Parekh and the Executive Committee of ISIL, decided to hold it uh, close to the Human Rights Day that is celebrated on 10th of December every year. So it's our good fortune that we are here on the 71st, on the eve of 74th anniversary of the Human Rights Movement, the adoption of Human Rights, Universal Declaration of Human Rights, and it's a fitting tribute to the memory of Justice Sachar that we are holding this lecture. It is my pleasant duty, first and foremost, on behalf of the society, to thank Honorable Justice P.S. Narasimha sir, for doing complete justice. I will borrow the word of Article 142 to the topic of right to food security. He has taken us completely from the theoretical perspective, the work of the Honorable Supreme Court in two phases, and wants it to be taken to the third phase so that the right is actually realized for the teeming millions who live in extreme conditions of poverty. Sanjay ji's book, Court and Hunger, that came to be released on this occasion, is my predecessors speaker have spoke eloquently about the book. As a matter of encouragement for all of those who are present, the publisher has put up a stall outside the auditorium and is offering a generous discount of 20%. So if anybody is interested, please do purchase it. Sir has gifted copies to our library, so all of you can read from there also. But it's having a personal copy is always better. Now, our president, Mr. P.H. Parekh, could not join us because of certain family circumstances. On his behalf and the members of the Executive Council of the Society, I convey to this august gathering our sincere gratitude for joining us on this occasion. I am equally thankful to Professor V.G. Hegde, Professor Manoj Kumar Sinha for taking out time from their busy schedule and making an address on this occasion. We are extremely grateful to the family of Justice Sachar for joining us on this occasion. Further, my colleagues in ISIL, Shri Vinay Singh, Dr. Anwar Sadat, Dr. Parneet Kaur, Dr. Kanika Sharma, Dr. Meenakshi Subhan, and the support staff make sincere efforts in making these programs successful and well attended. I profoundly thank them for their contribution. I am equally grateful to my colleagues in the Secretariat, Rakhi Bakshi ji, Santram ji, Ravender ji, Sanjay Kumar ji, and other support staff for their efforts. Please do pardon us in case there are any shortcomings or failing in the organization of these events. And let me request all of you to give a standing ovation to Justice Narasimha and the author of the book, P.S. Sanjay Parekh ji. To conclude, I once again sincerely thank all of you for joining us on this occasion. It is your presence that helps us in organizing this program. Thank you very much. Ma'am, please.
Ma'am is very good singer.
Are you
No
just
issues. Ma'am,
start with all the
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय जय